Good morning. Are you Leonard Gillery? And Mr. Gillery, in cause number 22-40982, on probation for unlawful possession of a firearm by a felon, that probation started last June of 2024. It was a 7-year deferred probation. Motion to revoke that unadjudicated probation has been filed. Looks like the primary two allegations are, one, that you have allegedly committed the offense of aggravated assault with a deadly weapon, June 19th of 2025, and also evading arrest or detention with a vehicle on that same date. The evading, has it not been filed or indicted? Okay.
Was it with a vehicle?
Yeah, it was with a vehicle. That's what, at least what the administrative hearing says, but
I don't know that it was with a vehicle.
I haven't seen anything about it evading.
I think
It was only the.
My recollection was that it was evading on foot. I'm happy to explore it.
that's okay. Let me look at this as well. And so I'm going to take judicial notice of the court's file in each case. The new alleged offense of aggravated assault has been indicted in cause number 25 DCCR 0902. There's a $200,000 bond set in that case, and there's no bond in the motion to adjudicate. Mr. Lewis has filed motions in each of those cases asking, one, that I set a bond in the motion and that I reduce that bond. In the new allegation, I'm printing out real quick the PC. I'm going to take judicial notice of that. Give me just a second to review it as well. Mr. Coleman has filed a response and reply to those motions to reduce, and I have reviewed that as well. Give me just a second. It was on foot, yeah.
That's what I thought, Judge. It allegedly was
Started on a bicycle.
Yeah, I don't know where they get the vehicle from.
Yeah, they wrote it wrong on the PC even. That's where it came from. All right, Mr. Lewis, do you wish to call your client?
Oh, ma'am. Judge, this is argument.
Okay, go ahead.
Judge, as far as with these motions, the motion to set bond, motion to adjudicate, of course, majority of this does deal with this new allegation. As far as the other conditions of probation Mr. Gillery had, it seems that he was doing well with that. He technically was not working at the time of the offense. He had basically a reduced workload. It was a layoff, but they have been called back to come back to work. He's trying to be able to bond out so he can get back to work, possibly even hire his own attorney, or at least be able to take care of his bills and things like that while we go through this process of taking care of this case. So he definitely would like that opportunity, at least by having a bond set on it with the MTRP. As far as the new case with the ag assault, understandably, it is will be considered a serious offense. We are asking for a reduction there, maybe in incorporating some bond conditions.
Now this is where the defense is trying to shift the narrative. Instead of focusing on the severity of the charges, they're highlighting stability, job, family, structure. And legally, that matters. Judges often weigh risk to the community versus likelihood the defendant will comply if released. GPS monitoring and curfews. That's basically the defense saying, you can control him without locking him up. Monitoring really be enough to justify.
Conditions that may secure any of the court's concerns with any public or private safety for the complainant witness or the general public while we're dealing with this, which could include, of course, GPS monitoring with with a curfew would allow him to be able to go work and be back home to at least be able to take care of these things. With his job, he would be able to afford the monitoring and GPS monitor. He does have some support, family support. His wife is here today, and has been here each time before she would come to court. And so that's what we ask for, Judge. Just, if they can get a bond that is a little more reasonable than 200,000, a bond that high. A lot of bonds from the courts, it's hard. A lot of them won't even touch that amount.
Relez interview 1, and just like that, the situation gets heavier. A new, possible allegation enters the picture, and this is exactly what can destroy a bond reduction argument. Because in the court's eyes, it's no longer just one bad decision. It starts to look like a pattern. And patterns? Judges don't ignore those.
So what is the status of the burglary of a vehicle in Hardin County from June 8th of this year? That's an allegation in the motion as well.
As far as I know,